I am the newest hire for Ask Resource Center. I'm actually only 1 month into my training, and very excited about everything that Ask has in terms of references and resources. I'm very excited for all the speakers and the great information that they have. So I'm going to go ahead and let our presenters introduce themselves. The one thing that we are asking is that we are using microphones. It doesn't project anything, but we're live recording everything so that we can put it on
the table.
Oh, absolutely, absolutely. We're live recording everything. That way, we can use it as a resource in the future. So if you do have a question, if you don't mind talking to the microphone, I know it's not the most ideal situation, but if you don't mind that, and then just one more reminder that if you have not already filled out your drawing paper by going to different vendors, there's going to be one more time in between this session and the next session, and then at 2:30 you can do drawing. So if you haven't had a chance to do that, please just go ahead and feel free to do that. So without any further ado, I will let you gentlemen take it away.
Thank you, Sarah. Yeah, we got a small group here. So, my name is Nathan. I'm an attorney for Disability Rights Iowa. Worked there for almost 10 years now, doing working in several different areas that have to do with youth and children. But for the purposes of this, I've done a lot of special education work where I'm representing parents and students where the schools are somehow violating federal and state rights of the student.
I'm Sandler. I'm at the University of Iowa Clinical Law Program, and I supervise second and third year law students. I've been doing special ed for a long time, but now mostly policy, not as much representation of individuals or parents, and we do a lot of consulting work. Well, in my first introduction to law in law school back in 1978 was a 6-year-old child with behavior problems who stabbed his teacher with a scissors. And the whole idea is what they were going to do to him, what the teacher as well, what the issues were with that, and also to terminate the parental rights of his mother, who also has significant intellectual impairments. That was my introduction. And I said, after this, it's going to be a bit easier, but it turns out it isn't.
Mm-hmm.
And each parent in each scenario is the same. So, and Nathan and I worked for several years on the task force that was set up to redraft and rewrite the rules for seclusion and restraints. So we know what's under the curtain, behind the curtain, and also what didn't get there. And this is your time, so maybe you could introduce yourself and tell us what you would like to get out of this session. We have a 55-page PowerPoint slide for you.
Take it all. Email it to me. The more information, the better.
Well, the
Okay.
materials are really good.
Great.
Chloe Kilpack, I'm the Significant Disabilities and Deafblind teacher at Iowa School for the Deaf. What I want to get out of this is anything you can give me. I feel like being in education, we're not getting a lot of information on what to do with this, just whatever our administration tells us at that time.
My name's Dawn Graber, and I recently filed a state complaint for Chapter 103 violations against my school district, and I have no legal background, and I hope I did it okay. But there are systemic issues in my school, and so I would just like to learn as much as possible about Chapter 103 and ways to make a dent, to make a systemic change, as well as help my son.
Yeah. How old?
19.
19.
My name is Paul Dombrowski. My son is 12. He has Down syndrome. Part of it is I know that my school district has gotten in trouble before with these issues. Iowa City School District. So that's part of the reason. He has a habit of knocking stuff off of tables or throwing things, which is, and doing late hitting, which is always viewed as aggression, but for him it's communication.
Mm-hmm. Mm-hmm.
And my biggest concern is getting to a point where they're not, it's gotten a lot better over the years, but I don't want it to get to a point where they're thinking that that is aggression to the point where he would need to be restrained or secluded. So I want to make sure I head that off at the pass.
Yeah. Yeah.
And those are all good concerns. And you're Iowa City,
Clear Creek, Amana, so close to Iowa City.
because the last federal complaint I saw for the Office of Civil Rights was Northeast Mahaska, but it's no longer pending. So I don't know what happened. They have a list
Okay.
of every school in the country for which there's a complaint as well, and I can always send you that.
Yeah, I would love to see that.
That place, and you can look and,
You said, though there was a state complaint, you
I
filed
wrote a
one.
state
Okay,
complaint,
got it.
yes.
Cool.
and I'll just do a quick intro, and then I think we can get into nuts and bolts and how it works as well, and we can go into each one of your specific questions, because there is no one-size-fits-all. The rules were specifically generalized to give, there are a few do's and there are a few don'ts, but the rest comes in the middle. And that's a lot of discretion, and that's what causes a lot of difficulty as well about interpretation and reviewing each action. So that's what we'll go through. And Chapter 103 is only one of the many laws. Because you have an arsenal, you have the IDEA, you have Section 504, which forbids discrimination and requires a free and appropriate public education, and also the ADA. But for the most part, it's going to be Chapter 103. And if the student has an IEP, then it would be IDEA as well. And the way the rules are written, everything is based on definitions. Okay, and that was sort of the centerpiece of it. So it's always a good place to start with definitions, because it's hard to understand the rest of the rules without looking at those first. And ask has, that's where it starts. And everything is staged. You know, the way we look at it and the way the rules were developed were to allow people to walk through them and understand the process. So, and the first stage is to understand that the Department of Education, in its points that they say that it's rare. It is a rare event that a teacher should use reasonable and necessary force. So right away, it's not a presumption, but when they say it's rare, it should not be the first response. And prepping from the teacher's perspective, okay, for the first time, there has to be very specific training and not just available to special ed teachers as well, and to learn evidence-based practices, which means there's got to be some research behind it, so they understand their duties and responsibilities, and they proactively look at things to prevent the interventions such as restraint and seclusion. That really is the last resort. And also to promote the positive classroom behavior management. And that's the essence of teaching, keeping a safe, secure environment. You have one of the handouts, which is actually the training from the law firm the state hires to represent the school districts do too. And that's really a good place to look at, because it breaks it down step by step and cautions when you should do things and when not, and what circumstances. And the idea is you try to anticipate behavior and not to be reactive. Now, I don't know what kind of training is given yet, except for the video, but when I was in the submarine service, we trained for fires. So we would put masks on if there was, battle stations or other things. We knew what to do, and they drilled it into us, but we don't have that kind of role play training yet in the schools, and that was something we hoped they would do. Also, parents in advance, the schools have to prepare them by providing information about the rules themselves. They have to provide their policies as well, written policies, and most of them make it available online, but they have to do it in paper as well. And usually they'll post their forms. Sometimes they will not, but if I was going in a scavenger hunt as a parent, my daughter's much older now, one of my granddaughters has the same issue, then what I want to do is find out where I can get the forms, both for the letters they're going to send, the notices and documents they're supposed to provide me after they take any action against my granddaughter, and also the next stages, which would be reporting and then debriefing. Also to find out during parent-teacher conferences, if you're looking about practicality, that's really the best place to go, even if it's an informal gathering, whether they call it a 504, an IEP, and that's the time to discuss, and Nathan will go through a little bit more on the difference with an IEP and the behavioral intervention plan and maybe safety plans, and if and when you should ever have seclusion or restraints included and what the consequences that might be. So here's from the teacher's perspective, right? You're supposed to anticipate what the student might do and then assess the risk. All this is based on before you can touch a student, right? In an effort to immobilize their hands or arms or legs or their mobility, you have to assess and see what the risk is to the student, to other students or teachers or others in the immediate area. And there's also a rule about property. And we can talk about that, but really it's going to be, and Nathan will go through the standard, about what the standards they use, what you need to have or observe about the child's behavior before you grab the child and immobilize them. Not escorting or moving them along, but to actually restrain them or to remove them physically or to place them in a designated room. And the idea is where is one of the big issues. What kind of room and rooms or areas can be used, how long they can keep the student there, and what they have to do if it goes beyond a certain amount of time. And there's the 15-minute rule. And then who do they have to notify? That's the next step. The minute you seclude or restrain, then the idea is how long do you have to be before you notify the parent or the legal guardian or someone who has an educational authorization. And when it ends, what do you do and what's supposed to happen? And that's what interferes a lot with education about what they do with my granddaughter after that. Do they kick her out or say, Len, pick her up? Or do they suspend her? Or do they put her back in the classroom? And how they evaluate what's going to happen. The next is to notify the parents in writing. At the end of the day, the school has to get together, and they have to put together notes and very detailed account of the incident with an effort to document what happened and also to document what they could have done differently. And then after that, the idea is you're supposed to notify the parents and then set up a meeting where they can debrief. That's pretty much the process about what they're supposed to do with an eye toward making sure the restraint or seclusion does not happen again if it is all possible. In the ideal world, that might happen. But the idea is to eliminate that is the first go-to or the second go-to. Try all the other interventions you've been trained for. And that's really the big picture of it. With the idea toward they shouldn't be restraining my granddaughter again. And if it happens again, who else should be involved? Okay, so before I turn it over to Nathan to go through,
I got that.
You've got that.
Go ahead.
You have specific questions?
We'll get into the specifics. And number one, these mics are going into, they're just for the recording. They're not actually projecting our voices. So if you're like, I don't think your mic's on, you're right. It's not on projecting to you all. So just to let you know, obviously no PowerPoint. These are solid documents. These are going to be what you take from this. These are going to be your reminders of what we're talking about here. This is what we would put on a PowerPoint anyway. Put these documents together, and both Len and I reviewed them before they actually published them a while back after we got our new iteration of the state regulations governing seclusion and restraint, and we think they're solid documents. And so, really, this is going to help you a lot if you have these and you keep them. It's your cheat sheet to this, which is the regs. The regs are very involved, but this condenses the regs into what you need to know. So everything that we're going to talk about here, or I'm about to talk about, is in these. You don't have to remember this. You don't have to be watching the PowerPoint for it. This is your cheat sheets. So as Len talked about, the regulations, which are state law, that has to do with the use of restraint and seclusion in schools, goes through, Len just gave an overview, right, of kind of the subjects that hits. And it walks through it in a way that kind of talks about what's the criteria for when a teacher can use restraint or seclusion, what happens, what do they have to do while that's happening, how long can it be, all that kind of stuff. What has to happen after, including notice to parents and documentation. What has to happen if, or when do debriefings have to occur? What's a debriefing and when does that have to occur? And then what documentation goes with that? And then if seclusion's used, what designated area they're using, what does that have to comply with, right? There's a bunch of things that room has to have or not have in it, right? So I'll walk through some highlights. I'm not going to read the whole rule, obviously. You guys would fall asleep. But I'll read through the highlights of what I think you want to know. And that is, number one, when can a teacher or staff member at a public school use restraint or seclusion? So, and I'll read this and go through each of these points. There's a few different criteria. One, to prevent or terminate an imminent threat of bodily injury to the student or others. So, that's one. So if I'm about to, I'll pick on Paul here, if I start taking steps towards Paul and I look like I'm about to hit him, that's when, if you're the teacher, you can step in and do a restraint, right? So that's a simple example of how that might be. Now, obviously, there's a lot more gray sometimes that happens in this, but I think when we have the words imminent threat and bodily injury, this is not about I say something to Paul across the room and then I walk over here, but I've kind of said, we've exchanged some words, there might be a beef, but I'm not necessarily going to do much. In fact, I might be going to do something else in the classroom. That's not going to be imminent, right? I'm not up in Paul's face. I'm not getting ready to throw down. So that's a more simple example of how this might be looked at, right? Okay, so there's that one criteria, right? Imminent threat of bodily injury to self or others. Another one, this is not an and, this is, set that one aside, that's one. Now another type of criteria that could be met without that being met is to prevent serious damage to property or significant monetary value or significant non-monetary value of importance. So, what that means, why that was put into the rule that way is folks like myself, Len, others that were seeing that before this was written in this way, before these regulations were written in this way, kids were getting restrained exactly. They broke a pencil, you destroyed property, you're getting restrained. And we were saying, look, we can't have that. We don't want that. Now, so we're talking about if I throw this laptop, that might be significant monetary value, right? If my school has a Mona Lisa, that would be wild if they did. If they did, and I destroyed that, that would be that next part, which is kind of the significant, well, that would be monetary value. I don't know what I'm talking about. What's a good example of a non-monetary, something that's, huh? That's of importance.
It's a remote.
Hard to.
It's not of significant importance to the learning environment, and it's not that expensive. Remember, everything is viewed retrospectively. Everything is looking back and say, what happened and why? It's not forward-thinking. The teachers are supposed to be forward-thinking and make a judgment call. Now, if I'm just throwing this, and it may break, it may not break, that's one thing. But if I'm throwing it at Paul or Bill, then that might be the imminent risk of bodily injury to them. So it's not, this is what we're talking about here is just throwing this on the floor, not aiming it at someone else.
So where I was going with this was, what's the example of a significant non-monetary value or importance? I think you nailed it. I think you mentioned, somebody over here mentioned pictures or something like that, that maybe are of some historical figure to that school, and it's irreplaceable, right? It's the only picture or something like that. So something like that. It might not cost a lot, but can't be replaced. So we've gone through 2 different criteria now. To prevent or terminate an imminent threat of bodily injury to the student or others, and then we got the property piece, right? So that's an either or. Then we got, this is another one, a third one. When the student's actions seriously disrupt the learning environment, or when physical restraint or seclusion is necessary to ensure the safety of the student and others. So we're back to safety stuff, and we're back to serious disruption. So if you have a student standing on the table, like that table right there, stomping up and down, the learning environment is seriously disrupted in that way, there's possible safety concerns at that point, then I think it's safe to say that the teacher can enter into a restraint at that time, right? And then what's also attached to that one is when you can only do that when less restrictive alternatives to seclusion or physical restraint would not be effective, would not be feasible, or have failed. So they've been tried, or you just can't do that in that moment. So that's kind of that's the criteria. That's when restraint can be used. That's when seclusion can be used. If things are happening that don't fit into that criteria, then that's when the school enters into other preventative measures, things like that. All the whole toolbox, the pantheon of what the school personnel have at their disposal can be used. And so I know there was concern when we were first trying to change these regulations from educators that all their tools would be taken away. And that's just not true. The tool of restraint, seclusion, is being limited to the circumstances that we just talked about. The entire other toolbox is there for use. And hopefully should be, right? Because we're trying to prevent those things from occurring in the first place, to de-escalate the situation before it gets to that place where there's really safety concerns, right? That's what the bottom line, right? All that criteria kind of places it in those kind of safety concerns or serious destruction of things, right? Either bodies or property. Go ahead.
You can just get some additional insights. There's the handout, the overview, Chapter 103. That was done by a law firm, and it's through the AEAs. And it will give you examples about what they mean as insignificant property or significant property. It's good to read because if you go to a meeting or you're involved in this, you can look at what their view is, what they're telling teachers, and what they're instructing their administrators to do. It's not that it's bedrock law, but they're going to have to defend that position and say, well, you said this was not significant and was not that big a deal. Why are you changing now that it's my son? What's different about it? So that's why we gave that as a copy. There's a video online as well, and it's on the document. I gave you the website. It's a YouTube with the same lawyer going through and telling teachers and special ed teachers and other para and other people involved in the school district about seclusion and restraints. So I would also advise you to look at that.
Yeah. The law firm that did that is Allers & Cooney, and they are a law firm that represents many, many different school districts across the state of Iowa, including the metro area here, and like I said, across the state. So I often see attorneys from their law firm on the other side of the table because I represent parents and students across Iowa, and so and they're solid attorneys, right? We may be adversarial in terms of our positions, but they're very solid attorneys, and that's a solid document. Okay, so then in the regulations you have time limitations. The time limitations can be there's some ins and outs of them, so I'm not going to go through all those ins and outs, but I will give you a few things to just keep in your head. One, if it's from 0 to 15 minutes, there's not much in terms of what has to happen in those within that time, right? But once you hit 15 minutes, then you start having to have administrators basically weigh in on this, right? Somebody's got to approve over 15 minutes. And so it's easier to think of this maybe in terms of a seclusion in this space. If you have seclusion lasting 20 minutes or so, that should have been approved at the 15-minute mark. If it was not, because there's essentially a situation where you can't get approval because the administrator that does this approval isn't around, so on and so forth, and the rules understand that life happens like that, then fine. But that has to be documented then in that document that would document that seclusion in this example for 20 minutes. There has to be something documented in there and say why they couldn't get that approval. An administrator was off taking care of another emergency that typically does this. Something like that, right? Has to be recorded in the document that documents this seclusion. We'll talk about those documents in a minute. And then, once you've got that initial approval for the initial 15 minutes, over 15 minutes, then it's every 30 minutes after that. So if you have a 50-minute seclusion, let's say, you've had to have documentation for at the 15-minute point, documentation. I don't mean documentation. You have to have approval at the 15-minute point, and then you got to have approval at that 45-minute point, right? Because that's 30 minutes from there. So that's, in terms of time limitations, that's new to these newer regulations. That wasn't in our previous regulations before 2021. Go ahead.
One of the things to do, I'll give the practical tips, is when you meet with the school, you're asking about it. Just ask who are the people you're designating, because you need to find out in larger schools, they may not be in the same building, and you got to find out who's the backup. So they're familiar. A lot of times, teachers get appointed things and they're never told. They said, okay, Lynn, you're up next, right? But they never told me I was the one who had to approve seclusion. So it's good to, and maybe to ask them if they do have a flow chart, if anything, about corresponding to the documentation and the timing, all of these, who does what, and who they report to, and think about what pieces of paper they have to fill out, but also who else can they call to assist them. And one of the issues we talk about is school resource officers.
Mm-hmm.
Well, just ask questions at any time.
Yeah.
Is it the legal standard for administrators, is it just that they have an administrator license, or do they have to be officially designated in this role of being able to approve this?
Okay. Good question. First of all, they have to be trained. Every person who's going to be involved or could possibly be involved is supposed to be trained and undergo the training. That's why they have the video. That's why they have the AEA doing it as well. And other schools have additional training. There are some firms that do this and have been doing it with special education and behavioral interventions for a long time. And then they are supposed to invite other people, such as SROs or volunteers or other people who might be involved, although they shouldn't. So that's the first thing. You don't need an extra license. It just means you have to be employed by the school district. And a lot of times the principal will be the administrator, right? And then they'll appoint someone, a designee. And it might be Chloe in her school. as well, and then there might be a backup. But the idea is, what plans do they have for a backup? And that's what I would ask as a teacher as well. Well, what if my para isn't there, or what if the person isn't? So ask questions. I know you're all self-advocates, and that's the hardest part of this, is being able to stand up to the principals and the 10 teachers and who's ever there and just ask. And that's what these documents are great for. They have the checklist. And all you can do is, oh, here's this checklist. Why don't we go through it together? Give them a copy.
This document right here.
Yeah.
Do they need to keep what kind of paper trail do they need to keep in this trail?
Okay.
So we're gonna,
That was next. Perfect segue.
exactly. So if restraint or seclusion is used, first, parents have to be notified in whatever way they've chosen to be notified for other things, such as something's happening in the school where we got to close down early, things like that, emergency notification system. So if it's by phone, by text, whatever that is, the school has to attempt to notify the parent either within an hour of the incident that occurred, the restraint or seclusion that occurred, or at least by the end of the school day. So they got to use that form of notification. Then they're also going to have to send this documentation that I'm about to talk about, and they got to send that to the parent either by mail within 3 school days, or you can do an electronic copy of it through the email, things like that, right, if the parent so chooses. So what is this document? What has to be in it? At minimum, you got to have name of the student, names of all the employees and people that were involved in the restraint. So basically everybody involved in the restraint, including the student, and anyone that approved, any length of time over 15 minutes, right? Also the date of the occurrence, beginning and end times, so we know how long it occurred, so how long the restraint occurred, how long the seclusion occurred. The date of the last completed training for any of the employees that were involved, any of the school employees. And then we're going to talk, it has to show the action of the student before, during, and after. Same with the staff. Before, during, and after. So that basically we have a complete narrative of what happened. Because ultimately, if you have to debrief this, which we'll talk about in a minute, what you're trying to understand, right, is the behavior chain. What was the antecedent event, was the beginning event that occurred that maybe triggered this all off. And then understanding what happened during the restraint, so we make sure that it's kosher, right, per the rules. And then what happened after, to see what were any of the incidents that what happened after as a consequence, right? And I don't mean consequence in terms of punishment. I'm just saying what happened as a result of. So that there can be somewhat of the possibility of doing some type of behavior analysis with this document maybe later if one needs to be done with a student with challenging behaviors, right? Okay, so that has to be in there. Any approvals, like I mentioned, description of less restrictive means. So what was attempted before, which kind of goes into that before part of what were the things that happened before the restraint or seclusion. Any injuries, descriptions of those. There's no requirement for pictures. I think that's good if you're either from the school side of things or a parent as a parent, request pictures be taken if that were to ever occur. Schools, I think that's a solid practice to take photos of injuries so that everybody's on the same page of what they are. And then, ultimately, future practices. Anything that could be done differently in the future to avoid a restraint or avoid a seclusion. So that's what has to be in that documentation. And school districts have different forms that they're using. I've seen a lot of different forms over my time. I don't care what form they use. I just care, does it have all that info on there? And obviously this info is important because the regulations require it, but it's also important because, as we talked about, we want to be able to use this document also to help teach us something about the moment, right? To teach everybody. So that gets to debriefing. Go ahead.
Well, you mentioned coaches. Come in. So a couple of other things. One, as a parent or teacher, you should make sure that they know what your emergency contact information is. And if you can, tell them you would like it in more than one way. So there may be a phone, but tell them you want it by email or text, because sometimes things go down, and phone as well. So you can ask them to do it more than one way. Some schools just have they have an emergency system and they want you to use that. But the regs allow you to ask for more. Also, the forms vary, as Nathan said. And what you want to make sure, there are forms you can fill out forms, and some give you a narrative, and others just put 4 words. Len threw something at Johnny. And I try to stop them. So one of the things is to ask, and you can look at the Aller's thing about how you're supposed to fill out those forms, and as a teacher, what you're told to write. One, because I think teachers, rightfully so, are going to be very defensive about what are they going to use these forms if I admit that I did something and I didn't give them 2 warnings, or I didn't try every behavioral. So that might squelch, being candid. So look at the forms and ask the teachers, or if you've had them, review them carefully and say during the next session, this really didn't tell me as much as I might need to know. So that's what the debriefing meeting might be for. One of the purposes is to say you get this piece of paper and it didn't tell you enough, and it's the obligation of the district and the parent to exchange that information. And the idea is going from saying, the teacher, I did this, to I did this, and now how should I do things differently? And that's the difference between the documentation at the stage immediately after. What they're supposed to do is, by the end of the day, the teacher, the principal, and anyone involved are supposed to get together and sit down and go over the documentation and write it out, and then notify it, send it to you as a parent. And then the next stage is the letter. Welcome, we want you to come in. And other questions you have as well?
Just regarding documentation, I know Chapter 103 says that the schools have to maintain the documentation.
Yep.
So what is the responsibility of the school to keep those documents from year to year? Does it have to be in the students' education?
That would be in their educational record and their CUME file then.
What gets reported to the Department of Ed?
So then there's a reporting requirement in terms of incidents of the incidents of restraint and seclusion. They're going to report in the manner prescribed by the department, annual count of all instances of seclusion or restraint, annual count of the number of students who were subjected to seclusion or restraint, and any other data required under Every Student Succeeds Act, which that includes a bunch of demographic data so that they can look at is there a disproportionate number of students with disabilities restrained or secluded in that district? Is there a disproportionate number of minorities secluded? Is there a disproportionate number by gender? So on and so forth. So that's what they're going to be looking at in that data. And yes.
The federal government imposes requirements as well, because school districts get federal money. So the Office of Civil Rights, and there have been some recent resolution agreements. They come into schools. There was one in Detroit last month, and they didn't have any of these, no documentation, nothing. And they said, here's what we want you to do from now on, and here's what you have to report. So there's statistics. And part of the issue for the federal government and for here in Iowa is that you also want to identify students who have had a repeated pattern of being restrained or secluded behavior that have not been identified as special education students or students with a disability. So part of it is to capture and identify students who really do need special instruction or need a plan that will allow them to continue in school rather than be expelled or jailed for their behavior. So, and that's really the interest of the federal government, making sure that we identify students. students as well. But the flip side of that is that students, especially students of color, were being identified as special ed students.
Yeah, there's the fine line of over-identification versus not identifying required by the Individuals with Disabilities Education Act, which has a child fine requirement that you find, locate, and evaluate anyone that's suspected of having a disability and see if they're going to be eligible for special education services. So some practical tips on these documents before we get into debriefing. When I get something in front of me where we have an intake and, I have a client that's been restrained or secluded a lot, I'm going to ask for those documents. They should have them in their file. If they don't, that's, red flag number one, that they're not doing these things right? Number two, I'm going to look at those documents when I get it, and if this kid is on IEP with a behavior intervention plan, I'm going to look and see, were they following the behavior intervention plan? Because the behavior intervention plan will have a listing of preventative strategies, right, for preventing challenging behaviors. And so I look through that to see, did the school personnel actually follow that plan? Because if they didn't, then for me that's an argument to say you're getting close to violating the requirements of the federal law, federal special education laws, right? So I'm connecting these documents to a few different things, and that's what I think parents can do as well. Just do a quick comparison. And then you can bring this up to the school either in an IEP team meeting or I would recommend in writing, notify them that I've noticed this. And I think we need to be implementing the BIP better with my child. For the school, if you're an administration or if you're a special education teacher and you have a para that was involved in a restraint where you see, we didn't quite use the BIP, this is an opportune time for coaching, training, trying to get people up to implementing the behavior intervention plan with fidelity. So these records can be used for more than just, this is what we have to do to have it comply with the law, and then we check that box and let's put it in a file. These should be documents that are kind of working documents that help us see if the student is on an IEP, are we implementing the IEP? And is it working? That's another thing. We got several different restraints or seclusions in a row. We're following the BIP, but it seems like some of these behaviors aren't even noted as behaviors of concern in the IEP. Maybe we need to meet again and do some more assessments. Maybe we need to reevaluate altogether. So these documents can be used as working documents as well, so that they're not just, this is what we got to do because now the state requires this. Does that make sense? Yeah.
Just ask Dawn, how did the school, what kind of quality of notice, how did they notify you, what kind of paper, what kind of information, what kind of information did they give to you about what happened?
They have a form. It hits maybe a third of what it's supposed to address. And then the forms that were lacking weren't even filled out very well for a form that was lacking. No information on debriefing. They didn't talk to me at all about debriefing. I discovered it myself and said, hey, we were supposed to debrief about that. And actually, at my so-and-so's computer, maybe dean of students' computer, just his narration, never sent home to parents, not in his educational record, and I was astounded.
It would be interesting if you want to follow up with us or to ask what corrective measures they take in response to the complaint, regardless of what, what happened itself, but you're identifying just what was not supposed to happen over 2 years and changing the entire system and putting in regs and the department promising to have this done as well.
And actually, they did have the correct forms on their district website, so I had access to their correct forms, and they were using incorrect
Correct.
forms. So there was knowledge, but no application.
Yeah.
And that's fairly horribly typical, is that we parents know more about the process because it's difficult to find lawyers. We know that. And two, we have to know more about our children and grandchildren than anyone else, including the school. So they're lucky to have you, put it that way.
Well, they don't see it that way right now, but
Oh,
maybe
they never
eventually.
will. That's okay.
We hope.
Yes.
Just a quick question. So the Chapter 103 rules apply to all students, not just students with special needs.
Correct.
Does the law have any special provisions for when a restraint or seclusion is done on, say, a nonverbal child or someone who is in terms of what communication are they allowed to have? Like, I've heard this really feel good, things like that.
Yep. So there's actually, these, I'm looking for it here, but yes, communication is taken into consideration in the regs, and so I'll read that part real quick. And these were in the regs previously from 2008. So this part's it's been the law, yeah. If an employee restrains a student who uses sign language or augmentative mode of communication as the student's primary mode of communication, the student shall be permitted to have the student's hands free of physical restraint unless doing so is not feasible in view of the threat posed. So that's where that's addressed. Now, when I've encountered this before, my client shouldn't, there was more going, the restraint that happened was an issue, but what was more of an issue was the actual plan in place for prevention because it wasn't taking into account the nonverbal part of the behavior at hand. The frustration that was happening because of the struggle to communicate was not being taken into account. So this young person was being restrained quite a bit and also secluded after those restraints because things then escalated because of the restraint. And so when we were able to get to that piece and begin to put some supports and services in place with that piece and get, in this instance, some folks from the AEA involved with the school district to help provide training, coaching, information, so on and so forth, then there were less restraints, and then you don't even have to worry about, the exception's important, but then you don't even have to think about that as much because this student wasn't being restrained as much at all. Actually went down to 0 restraints.
They copied the policy from the police. We rewrote the ones for Davenport for individuals who are deaf and hard of hearing. And that was one of the issues, especially whether it's a witness or someone because of domestic violence. They didn't know, you don't know who's the aggressor sometimes, and that was the whole idea. They were trained by people, I think DEA, Deaf Islands Against Abuse, and the training was only restrain if there's a physical threat to you in order to have that person communicate. You also have to get an interpreter as soon as you can.
I think that's where we run into issues. All of our students use sign language.
Yeah.
Many of our staff are deaf themselves. So when we are trying to restrain, one, you've got to be cognizant of the student being able to communicate, but then the two that are restraining, if one of them's deaf, we can't communicate with each other, so then we're relying on a third person, and then there's no communication happening, and it just isn't going well.
Right. That's a very complicated situation.
So are there other
That's not good.
physical things that you can do? Because restraint is immobilizing or pulling down. Are there other physical things that you can do and
So I'm not directly
that would
involved.
not impinge on
Right.
the person's ability to communicate? Because that's where I think there are other people outside the school district who would be better at that as
Right.
well.
I'm not directly involved with the one student that is restrained frequently, but I am sometimes brought in as a behavior specialist to help de-escalate
Mhm.
because they don't are, all of our contact with the team on campus is all through text or FaceTime, and then, that's hard to do in the moment too. So our admin is not always there, so they bring them into, they call it a conference room in our elementary building. But he will try to break out the windows, we have uncertified staff trying to deal with it. It's just,
And with that kind of repeated behavior and assaultive behavior, then I would have expected there would have been suspension or expulsion at a certain point.
so they've suspended, the family's actually gone through due process with the school because we're a specialized school.
How long ago was that?
Oh, it's been a while,
Like 2 years?
yeah.
Yeah, that's a DRI case. That's,
Yep.
I was there. We should probably not talk much more now. But good to know that this is still an issue.
And we would talk about other groups and other schools for the deaf and other institutions. And also sometimes, even though they don't want to, inpatient psychiatric as well, because the healthcare systems, many of them, have different tools for doing it and get much more training. So we just try to go out and find who knows this and who knows both the culture and also of the classroom and communication. So that's something I would ask the school. I know we don't have a lot of time left, and you brought up a great issue. First, we can do Bill's question quickly, but you brought up this idea that a student stabbed you or assaulted you. So do you have a quick question, Bill? Because I just wanted to make sure that Chloe.
Well, I just wanted to comment, it's more of just a comment, but I was interested in your take, but I'm surprised in the rules and laws that there's not that additional follow-up, considering there's been so many medical issues that happen long after restraint. So, I spent a lot of time in the residential program, and it was always like, what did you see 4 hours after fight? Because even just a 15-minute restraint, the physical exhaustion on the staff or the person being served, I mean, I can't imagine.
Yeah.
I can't imagine 15 minutes. And then
Right.
because it was pretty thorough, but then I was like looking as I was digging through there to find who's following up an hour later, 3 hours later. So,
Yeah, these regs do not have that element of follow-up that you would have in a psychiatric medical institute for children, a PMIC, for example, that is governed by federal regulations that have these requirements for follow-up and quite frankly, follow-up by medical personnel, nurses, doctors, so on and so forth, that yes, this is not in there, nor would we probably ever be able to get there as advocates in changing the regs for that. So, you have debriefing requirements. Those are not the observation requirements that you're talking about. You have the debriefing requirements where maybe that can be brought up by the parent at that time, particularly if the parent is seeing things at when the child comes home from school. So obviously, practice tip for parents is document photos, write down what you see so that at least you can remember what that was, and then talk to the school about it. And it obviously, if you think your child needs medical attention, yes, go do that and get documentation from medical personnel. But yes, you're right; those are not in these regs.
Nor
Those kind of follow-ups are not.
that's serious restraint, and then if I'm notified till the next day, you're right, I don't think it's put in there, but I think when that was
There-
the federal regulations for providers, I think a lot of them said, you know what, we're not able to do that correctly, we should, get rid of doing restraint. Maybe if you take that out of your toolbox, you gotta build relationships, you gotta learn antecedents, you
Yep.
gotta learn personalities, you
Yep.
gotta get rid of all that other stuff.
Yep.
and the
100%.
The students leave, and they just go home. issue about the teachers and the follow-up was purposely not put in the rules because teachers didn't think it was the proper province. So the teachers have to look and say, you know, for their bargaining unit or their district or IEA, SEA, or whoever, if they belong to it, what kind of services do I get as well? What kind of healthcare or other treatments, or what happens if I have stress, or what do I do, and what are my rights as well? Because I know the lawyer for the schools was adamant about what went in right and what did not. So can we just go back, Chloe, knowing that you're not in an institutional setting where people are there under lock and key?
Right, yeah.
And
so-
what happened and what were your issues?
So the
Thank you,
student's
Bill.
been relatively aggressive all year, to all staff, is supposed to have a one-to-one paraprofessional throughout the day. She's now had 10 just this school year because she is so aggressive. People just have quit or refuse to work with her. So that generally falls back on me as the classroom teacher. And one day, very non-compliant all day, she was walking to go get a work box, just turned around and attacked me. Nothing, and she had been fine the previous 15 minutes. Went to the emergency room just to make sure we still had a heartbeat on my baby, and the school did no follow-up, no manifestation, no suspension for the student. Parents weren't notified. I was on workman's comp leave for 2 days, and in those 2 days, she had attacked another student, and that student's parents were not notified. And it's just kind of been pushed under the rug. So within the last, this has probably been 6 weeks ago that it happened, and since then I have threatened a lawyer. I've done everything to try to protect myself. And so their solution was to put up padding in the room for a seclusion room for the student, or to have me essentially wear a duct taped pad around my stomach, which there is no medical grade padding to do that. So that's where we're at with 15 days left of school, and the student is still absolutely beyond aggressive.
Isn't that a state school, or is it?
It is, we fall under the Board of Regents.
Yeah.
Yep.
So it's the state, and you're following the state's rules.
Correct, yes.
Yes.
Mhm.
Anybody can file a complaint, whether or not they're representing a child or they themselves have a disability. And that's how the seclusion issues came up in Iowa City. Mary Richards did it and filed. She's an attorney, but she filed as someone, and the federal government will accept that, and the state will.
You can file as what's called an organization.
Yeah. And so that's one way to do it. Another way is to speak with the attorney that represents teachers as well, because that was one of the scenarios that was actually discussed when we were drafting the rules. What constitutes physical contact to a teacher or risk that would allow you to seclude or restrain? And one was kicking a teacher, one who wasn't pregnant, the other was. And the idea was we were struggling over the word serious bodily injury versus bodily injury. And no one could tell the difference. We wanted serious because we wanted to make sure that it wasn't just a slap and that would be enough. But what came out is the representative for the school teacher said that would be in his
So we
purview.
don't, because we're under the Board of Regents, we don't have a union.
But
The teachers
you
don't.
can, you can still file a
Okay.
complaint.
Okay.
And I know you said you wanted to speak about private counsel, but the idea is what do you want the school to do besides follow the law? It's what's going to happen to the student, and that's not in they should have followed the requirements, but the decision about what to do with the student after, that's the hard part but repeated instances, I'm surprised again that the person wasn't suspended, expelled, or you get to the
Well,
team.
let's not advocate.
I'm not saying that.
Let's not go that direct.
But that's-
Well, I mean, because
that's
you
what
got
we
a whole
wanted to
slew of
stop.
laws that, yes.
Yes, exactly. That's not
There's a
supposed
whole-
to be the response. No,
Yeah, what really, the real response should be, where are the specialists?
Yeah.
Where are they calling in the troops, the specialists, to get involved, to understand what's going on with this young person, so that they can break the behavior chain? That's one of the main things that needs to be happening, because restraint, seclusion, suspension, expulsion, all those things are not necessarily special education. They are not special education services. They are general education interventions. And so this child obviously is there because this child has a disability. This child obviously has an IEP there. And therefore, this child should have some kind of reevaluation, reassessment being done. If, one, are these behaviors the same behaviors of concern in that IEP? If so, then whatever's being done is not working. Not blaming anybody, it's just saying maybe that's not the interventions. Maybe new ones need to be done. If there are new behaviors or other behaviors that are popping up that are not in there, then a full reevaluation probably needs to be done. But you need some specialists in there understanding what's going on. That's the yes, documentation's a problem. None of these things are good at all. And the student's being completely failed, and therefore you're being failed and everybody else is being failed around him because y'all need help. Somebody needs to help.
And that was in the rules, we were trying to find out how many times a student had to be subject to restraint or seclusion before they convened outside experts. And we were trying to come up with 3 per year, and the idea was, what the department is supposed to be enforcing is saying if the behaviors recur, then something's wrong with whatever plans you have. And you have to bring in outside experts that are not available through the school or the EAA or the district. And a lot of times those are behavioral specialists. So
That's in the debriefing requirements that we didn't quite get to, but you'll see that there. And the real quick of it is on the first instance of restraint or seclusion in the school year, you got to debrief. So the school's got to notify parents, you have a right to this debriefing meeting. It can happen within 10 days of the incident. Let's have it. Then that meeting gets documented, and there's requirements for that kind of documentation. That's when that person that Len just mentioned can be part of it. It says an expert in behavioral health, mental health, or another appropriate discipline can be included in these meetings and should be based on the instances of seclusion. You also have to have one of those debriefing meetings then after 7 total instances in the year. And the point of that was what Len was getting at. Everybody should be seeing this as red flags, danger, danger. Everybody stop. We need to reassess. Let's get some people in here to figure this out. That's kind of the point, right?
Thanks for the reassessment.
Yeah.
Is that the school?
Yes.
yeah.
And
the payment is the hard part. They're going to resist because they didn't want to pay for the outside expert. And
But-
that's when you can make a call
yeah.
Yeah, okay.
to IDO, to the state office. There's certain people, and I think that's knowing who to connect in that office. Because one call is probably worth trying to go through the school district and the superintendent and the board.
If I could have you guys fill out your evaluations.
So thank you.
Just did it.
Great questions.
Thank you. So if you guys could do that.
Yeah, thank you all.
for me. And if you guys, any of these papers that have the ask on it, if you use this paper. if
Yeah, thank you. Nice job as well.
That plus more
Should
is
take
on
the
the
show on
website,
the
but
road.
if you feel like you have lost it,
How are
don't
you?
panic.
Hey, what's up? How you doing?
I'm good.
Yeah?
Yeah.
Good. We are overworked at DRI. Thank you. Appreciate that. Were you in this session?
No, I was
gonna say,
down there in B.
Yeah. Got it.
Thank you, I appreciate it.
Well, it's good seeing you. I just wanted to say hello.
My mom is too much out. I know, I'm supposed to be leaving.
Did you say that I know we ran out of time, but you're going to address whether you should have restraint and seclusion in the BIP?
Oh, okay. My take on that is what I advise my clients is, no.
Don't even
Get that
put those
out.
words in there.
And here's why. I mean,
Okay, there's mine.
let me say why people think they should first, and then I'll say why I think not.
Okay?
So there's the argument that, well, if the school's gonna do it, we want it individualized. So we need to put it in there, because it has to
Right.
be individualized, it's put in there, right?
Right.
My thought is, I haven't seen that practically pan out very well. What I
Okay.
see happen is if it's in the safety plan,
Okay, it's almost a
it's,
license.
it's rarely, right, and it's rarely individualized then, so it's not,
Right.
that's just gen ed then. So
Right.
it shouldn't be in that document.
Right,
And then, yes, then it's jumped to, something happens, I think, in people's minds when they see it in there.
right,
They jump over all the steps right to there.
right.
And so I advise clients like, hey, don't have that in your safety plan at all.
Okay,
That doesn't mean the school can't do it, the school can do it.
right,
and-
they've got the rules right
Yep,
there,
and
yeah,
they can do that for any student.
right.
And so
Yeah.
that's just good enough to have it in there, I think.
And if it is in there, according to chapter 103, doesn't it have to be, it has to have specificity?
Yeah, it has to be designed to meet that student's unique needs.
Right, so
And
not
rarely
just
does it.
when,
Right.
not what we're gonna lead up to.
No,
It's specificity about how we are going to
Yep.
do the restraint on
Yep.
this child
Yep.
who's nonverbal or who
Yep.
is short or tall or strong or weak or whatever.
Exactly.
Right,
exactly, and
Right.
any other specificity. And
Right.
like I said, I have I shouldn't say rarely, I have never
yeah.
seen one in my years of practice
Mhm.
that's specific.
That meets that specificity
Yeah.
requirement in chapter 103. Okay,
So
great.
I just say,
Thank you so
don't
much.
do it.
Yeah, yeah.
Yeah.
Thank you.
Quick sheet. Oh, Gail, that was great, thank you.
Just see if you're representing this
Oh,
too, or
no, Len is doing this one on his own.
Okay, sure. Yeah, thank you.
All right, Len.
No, you're doing it as well.
Want me to sit and critique
Oh.
from the back?
Heckle, it's the best way,
I don't know, Len, I disagree.
Give that one another bourbon.
See it.
Have fun.
Me too.
Oh,
Nope, that's one stash. Would you like some too?
Yes.
Doing my job as a lawyer and papering you as well.
Oh, that's just a call for one person?
Yep. So you can take things home. The idea is. Oh, this might be easier if people converge a bit, if you don't mind. Also, oh, there goes the projector. Oh, Sarah. So Sarah, what is your cheat sheet here?
Yes.
3 mice or something? Oh, there it is.
Yep, capital T, HRE, number 3.
3 mice. Oh. 3.
Yes, all of our passwords are grocery rhymes.
Okay, just 1, 3, 3, and capital M, I, C, E.
You must be Len
is that right?
Yes.
Hi, Lynn. I'm Jessica, and I'm
Hi.
going to help with being the host room today. I needed to ask, are you wanting to introduce yourself, or do you need me to introduce
I
you?
can just do it, I
Okay,
think.
okay.
So,
And it sounds like you've been here a little bit anyway, so you're...
I've been here for the last
Okay.
hour.
Okay. So you're